Hello, my name is Recipients, and I'm an attorney at MNK Law, a boutique law firm based in Los Angeles County. At MNK, we are more than lawyers. We are also business advisors. Everyone, employers and employees alike, are familiar with employee handbooks. Employee handbooks are as seemingly as ubiquitous as employee email accounts are. What is less familiar, however, are some of the common issues or hazards that arise with employee handbooks. Today, we're going to talk about some of the top issues that we have seen when it comes to employee handbooks. But before diving further into this topic, let me answer a question that we frequently get. Are employee handbooks legally mandated? The answer is no, they are not. That said, there are good reasons to have employee handbooks, not the least of which is that they establish a uniform set of rules and policies and expectations for employees. Also, let me add a word of caution. Your employee handbooks can and will be used against you. It is not enough to set up policies if your HR team and managers are not aware of them and if they're not adhered to. While we hope it never gets to this point, your employee handbook will be read out loud in front of a jury and can be used against you. Now, moving on to the topic at hand. Here are the top 7 things or so to look out for in your employee handbook. 1. Do not say that the employee handbook constitutes or reflects the terms of a contract of employment. Tempting as that might be, do not do that. Doing so subjects your business to claims that its employees are something other than employed at will. That is to say that they may only be terminated for a cause, that is, illegally recognized reasons. So don't limit your freedom. Number 2, ensure that your employee handbooks, paid sick time or PTO policies are at least as generous as those required by California law and, if applicable, local law. You may have heard that California law requires employers to provide at least 24 hours or 3 days of paid sick time to employees each year. But some counties in California, such as Los Angeles and San Francisco, have heightened paid sick time requirements. It's imperative that your employee handbook clearly provide employees with paid sick time that is at least as generous as the applicable legal requirements. This means that you must review any state and local law on point before finalizing your employee handbook. Number 3, speaking of paid sick time, be sure that your employee handbook does not say that paid sick time is limited to, well, paid sick time. We know this is counterintuitive, but despite its name, California paid sick time may be used for non-sickness purposes, such as when an employee is unfortunately a victim of domestic violence or stalking. Too often, employers miss this fact. Number 4, meal and rest period policies. Meal and rest periods are a hot topic, and plaintiffs' attorneys virtually almost always turn to this section of the employee handbook to prove that an employer systematically violated California's meal and rest period laws. Double and triple check these sections of your handbook. Your employees must be free and clear to leave their work area during their rest and meal periods. Uncompliant written policies are class action plaintiffs' attorneys' counsel's dream come true. Call employment counsel if you have any doubts. Number 5, disciplinary action. This too is critical. Too often employee handbooks add too much detail about the disciplinary process. Don't. Doing so limits your discretion to discipline an employee on an as-needed, case-by-case basis. Instead, simply say that the company reserves the right to use its judgment to impose disciplinary action as deemed appropriate by the case. Number 6, leave of absences. Leave of absences are extremely tricky. You must ensure that your leave of absence section complies with all legal requirements. Otherwise, employees may be inadvertently entitled to extended leave periods based on a mistaken policy statement in your employee handbook. 7, have a well-defined anti-discrimination and anti-harassment policy. In an era in which we live, it is imperative that employers have a well-defined anti-discrimination and anti-harassment policies in place. Don't skimp on this area to save space. In short, there's a lot of pieces to an employee handbook, but we are here to help. Should you need some assistance, please visit us at mnklawyers.com or email us at info@mnklawyers.com. We'd be honored to help you.